TCC Judgment 111, Champagne 4, 2026. The TCC delivered its judgment on the case on the scope of the principle of indivisibility of appeal in criminal proceedings on May 8, 2026. Article 348, paragraph 2 of the Code of Criminal Procedure stipulates relevant parts of the partial judgment appealed are considered as appealed. In Supreme Court Precedent 29 Shang 3382 of 1940, it was ruled that the prosecuted matters involve a single act that gave rise to several offenses, and the parties appeal only the convicted part and not those found not guilty. The indivisible nature of the trial entails that pursuant to the Code of Criminal Procedure, same content as the disputed provision, the matters related to the appeal parts are deemed appealed as well, and the appellate court must therefore render a judgment based on all indicted matters. The disputed provision and the precedent illustrate how the principle of indivisibility of appeal, under which an appeal against one part of a judgment may extend to the other parts that are indivisibly connected to the appeal part, work in criminal proceedings. Question arises as to whether such an extension in the scope of appeal in criminal cases violated the constitutional protection of individual liberty and the right to institute legal proceedings under Article 8 and 16 of the Constitution. The petitioner of this case was charged with offenses under the Soil and Water Conservation Act. Here in after offense A, Slope Land Conservation and Utilization Act, here in after offense B, and the Anti-Corruption Act, here in after offense C, and the offense of making false entries in business document under Article 215 of the Criminal Code, here in after offense D. The Court of First Instance deemed offense B a special regulation of offense A and convicted the petitioner of offense B and acquitted the petitioner of offense C and D due to lack of evidence. The appellate court upheld said decision. Subsequently, the Supreme Court quashed thrice the decision of appellate court for retrial, during which the acquittal of offense D was never appealed by the defense or by the prosecutor. However, since the face of the offense D was indivisible from the matters under appeal, it was considered appealed and remanded together in accordance with the disputed provision and the disputed precedent, and under the principle of indivisibility of appeal. Upon the second retrial in 2010, the appellate court amended the indictment and changing the cited statute for offense D to Article 215 and 216 of the Criminal Code, where the 216 is the circulation of document with false entries. Ultimately, the appellate court convicted the petitioner with offense D upon the fourth retrial in 2013. The prosecutor's appeal to the Supreme Court was dismissed in 2040. Subsequent extraordinary appeals were dismissed between 2014 and 2016. The petitioner lodged for constitutional review against the disputed provision and the precedent, as well as the constitutional complaint against the final court decision in the case. Following TCC Judgment 114, Champagne 1, Judgment 115, Champagne 4 was rendered on May 8, 2026 by a bench of 5 justices, excluding the 3 justices who refused to participate. Decision of the court. The TCC held that the disputed provision is constitutional, so long as it is construed not applicable to the parts that were found not guilty by the previous trial. The TCC court emphasized that the decision on whether the unappealed part are indivisible and should be transferred with the appeal must be based on the finding of the previous trial and the scope designated in the party's motion to appeal. When the parties do not appeal on the part that were found not guilty, the TCC held that the principle of no trial without complaint shall apply, and the said part shall not be subject to appellate trial. The TCC declared the disputed precedent unconstitutional for violating the protection of individual liberty and the right to institute legal proceeding under Article 8 and 16 of the Constitution. The TCC noted that the disputed precedent allowed the scope of appeal to exceed the part where the parties have a motion to appeal, consequently violating the principle of no trial without complaint. The TCC dismissed the constitutional complaint, but ruled that the petitioner may seek a remedy under Article 91, Paragraph 2 of the Constitutional Code, Procedure 8, apply mutatis mutandis through the second sentence of Article 92, Paragraph 2.